Keeler versus Superior Court of Amador County, Supreme Court of California, in-bank 1970. Criminal law, moral and constitutional limits on the criminal sanction, legality. Facts. Mr. Keeler is the petitioner and former husband of Mrs. Teresa Keeler. The Keelers obtained a divorce on September 27, 1968, after 16 years of marriage. Petitioner Mr. Keeler was given custody of their two daughters, aged 12 and 13 years. Under the divorce decree, Mrs. Keeler had the right to take the daughters on alternate weekends. Unknown to the petitioner, Mrs. Keeler was pregnant by Ernest Vogt, with whom she was living at the time, but she concealed that fact from the petitioner. On February 23, 1969, Mrs. Keeler was driving after delivering the girls to their home when she encountered petitioner Mr. Keeler driving on the opposite side of the road. After he blocked the road with his vehicle, she pulled over to the side and Mr. Keeler approached her seeming calm. He walked over her and started speaking to her. She rolled down her window to hear him. He said, "I hear you're pregnant. If you are, you had better stay away from the girls and from here." She did not reply and he opened the car door. She later testified, "He assisted me out of my car. It wasn't roughly at this time." Petitioner then looked at her abdomen and became extremely upset. He said, "You sure are. I'm going to stomp it out of you." He pushed her against the car, shoved his knee into her abdomen, and struck her in the face with several blows. She fainted, and when she regained consciousness, petitioner had departed. Mrs. Keeler drove back to Stockton, where the police and medical assistants were summoned. She had suffered substantial facial injuries, as well as extensive bruising of the abdominal wall. Mrs. Keeler underwent a cesarean section, and the fetus was examined in utero. Its head was found to be severely fractured, and it was delivered stillborn. According to the pathologist, the cause of the death was skull fracture with consequent cerebral hemorrhaging. The fetus's death would have been immediate and could have been the result of force applied to the mother's abdomen. Expert testimony concluded that, with reasonable medical certainty, that the fetus had developed to the stage of viability, that is, in the event of premature birth on the date in question, it would have had a 75% to 96% chance of survival. Petitioner was charged with committing the crime of murder, pursuant Penal Code Section 187, in that he did unlawfully kill a human being, to wit baby girl Vogt, with malice aforethought. In count 2 he was charged with willful infliction of traumatic injury upon his ex-wife, pursuant Penal Code Section 273D, and in count 3 with assault on her by means of force likely to produce great bodily injury, pursuant Penal Code Section 245. His motion to set aside the information due to lack of probable cause, pursuant Penal Code Section 995, was denied, and petitioner now seeks a writ of prohibitions. Issue: whether or not an unborn but viable fetus is a human being within the meaning of the California statute defining murder, pursuant Penal Code 187. Penal Code Section 187 provides, "Murder is the unlawful killing of a human being with malice aforethought." The Born Alive Standard. Common law regarded abortion as murder, only if the fetus is first quickened, second born alive, third lives for a brief interval, and fourth then dies. A viable fetus in the process of being born is a human being within the meaning of the homicide statutes. Analysis. This court determined that the legislature did not intend to apply the meaning of a human being to an unborn but viable fetus, and to construe that statute defining murder, pursuant Penal Code 187, would exceed the judicial power of the court and deny the petitioner due process of the law. Judicial enlargement of Section 187 of the Penal Code would not have been foreseeable to this petitioner, and therefore its adoption at this time would deny him due process of the law. Conclusion: no, an unborn but viable fetus is not a human being within the meaning of the California statute defining murder, pursuant Penal Code Section 187. A peremptory writ of prohibition was issued, restraining respondent court from taking any further proceeding on count 1 of the information charging petitioner with the crime of murder.